Hi, it's the Florida Law Guy. Today I'm going to help try to make Florida law simple by talking to you about what judges look at when trying to make a determination of bail. Judges do not use a mathematical formula when setting bail. Instead, the decision as to the amount of a defendant's bail is based upon the judge's discretion. Because of this discretion, one judge might set bond a little bit higher than another judge under the exact same circumstances. However, in order to promote justice, most judges are aware that it's important for their rulings to be consistent with previous rulings and with each other's rulings. Therefore, even though there's some variance, it's normally not that major. You won't often find a rogue judge setting bail at $100,000 when the typical bail is $10,000. When setting the bail amount, judges are supposed to set it at the minimal amount necessary to do two things. One, making sure that the defendant shows up for court if released on bail, and two, protecting the community from danger from the defendant if released on bail. According to Florida Statute 903.046, the judge must consider these 10 factors when deciding bail or conditions of bail. 1. The judge looks at the nature and circumstances of the offense charged. Obviously, the more serious the crime, normally the higher the bail. However, violent misdemeanors often have more restrictions than nonviolent felonies. 2. The judge looks at the weight of the evidence against the defendant. Obviously, the stronger the state's case, the more likely a person is to be a flight risk. 3. The judge looks at the defendant's family ties, length of residence in the community, employment history, financial resources, and their mental condition. A person with deep roots in the community, with large families and kids in school, who are small business and homeowners with a steady, high-paying job, these people are less likely to leave it all behind by jumping bail than an unemployed, mentally unstable, out-of-state tourist without a wife or kids. However, judges also have to notice the financial resources when setting bail. $1,000 bail might be enough to make a poor person show up for court, while $100,000 might not be enough for a multimillionaire. 4. The judge looks at the defendant's past and present conduct, including any record of convictions, previous flight to avoid prosecution, or failure to appear at court proceedings. Those with prior convictions are considered to be riskier to the community, so generally they have higher bail than first-time offenders. However, if the person's never jumped bail in the past or broke any laws when they got arrested previously, then that's a reason for giving a lower bail. 5. The judge looks at the nature and probability of danger which the defendant's release poses to the community. However, if the judge does think that the defendant poses a danger to the community, there are alternatives that can be argued to be imposed instead of higher bail. For instance, the judge could order home detention with an ankle bracelet as a condition of bail, or that the defendant wear a scram device so they don't drink alcohol while out on bail. 6. The judge looks at the source of funds that the defendant could use to post bail. Is the bail money coming from illegal criminal sources like drug money or money laundering? 7. The judge looks at whether the defendant is already on release pending resolution of another criminal proceeding or on probation. Well, if the defendant is out on bond and doing what they're supposed to do, not committing crimes and aren't a danger, that's an argument for a low bail. 8. The judge looks at the nature and probability of intimidation and danger to victims. Violent crimes, domestic crimes, sexual crimes, and crimes alleged against children are all crimes in which judges impose no contact provisions preventing contact with the victim. 9. The judge looks at whether there is probable cause to believe the defendant committed a new crime while on pretrial release. Obviously, if that happens, the person's probably going to be denied bail anyway. 10. The judge looks at any other facts that the court considers relevant. Any reason that shows you are not a flight risk or a danger to the community is something that the judge can consider. Remember, it's a balancing test. On one hand, the judge looks at all the reasons for setting a high bond, but on the other hand, the judge looks at all the reasons for setting a low bond. It's in his discretion, so anything that can be argued should be argued. It's completely free, so please support my mission to help make Florida law simple for the public to understand by liking and clicking the subscribe button. The way YouTube's algorithms work, the more likes and subscriptions a channel gets, the easier it is for others to be able to find it. So by subscribing, you'll also be helping others. Thanks for watching. See you next time.